What is your salary? What are your entitlements? What is the bonus structure? All of the components that will govern this relationship is written in this one document. That is why it's very, very important for you to understand whether you're an employer or a new employee. What are these components? Hello everyone, my name is Jana Krishnan and welcome back to the Daily Lawyer channel. Today we are going to delve deep into the world of employment contracts. Yes, those crucial documents that govern your employer-employee relationship. But the first question you're probably going to ask is, what is an employment contract? An employment contract, in very simple terms, is that document, those pieces of paper that sets out, that is, what are your expectations, the company's expectations from you as an employee. So what are your obligations as an employee? What are the company's obligations? What are your rights as an employee? What is your salary? What are your entitlements? What is the bonus structure? All of the components that will govern this relationship is written in this one document. That is why it's very, very important for you to understand whether you're an employer or a new employee. What are these components? A general understanding of these components is essential for you to know what you're signing up for. The first thing I'm going to speak about is from the employee's perspective. If you are an employee, then here are some of the things that you must see in your employment contract. When you get the employment contract, please do not just sign it, read it carefully and check for all of these things. The first thing you will check for is your name and your address and your details, so your PAN number, your Aadhaar number, whatever it is that you have been asked for, and more importantly, the name of the company that is hiring you. Sometimes the name of the company that is hiring you may be different, the legal entity may be different, and you need to make sure that you are being hired by the correct legal entity. And if you are in doubt, please ask HR. Please get clarifications. There is no problem if you ask for clarifications on this point. The second thing you're going to check is your salary clause. Sometimes salary is written on an annual basis. Sometimes it's written on a monthly basis. Sometimes you have something called CTC, which is cost to company, which includes a lot more than just the money that's going to come into your hand every month. If you are confused about this, please ask. Or if you don't want to go all the way to the HR, you can ask an HR friend, a family member, or another lawyer for help to decode these things in an employment contract before you probably want to go to the HR of the company that you're going to eventually join. The third thing that you must see is the length of employment. Does it say full-time exclusive service? Because if it says full-time exclusive service on your employment contract, that means you are going to be employed by them full-time. You technically cannot take up another employment of the same and similar nature on the side because you've contracted to give your time exclusively to this one company. If it doesn't say that, or if you have an arrangement with the company that you're going to come as a consultant or on a part-time basis, or you're going to be an advisor, then these words will not be there. Instead, you may have words that may signify maybe it's a 1-month engagement, or maybe it's a 1-year engagement, maybe it's a project-based engagement. All of these things must be clearly reflected in the employment contract, so make sure that you check for that. The third thing that you will check for are what are your entitlements and bonuses and other benefits that you get with your employment. So if you're in a full-time employment, then there are certain statutory benefits that you are supposed to get if the company has more than 10 people or more than 20 people, as the case may be, like provident fund or gratuity or state insurance and so on. Also, you may want to check what is the bonus structure. Is there a variable bonus? Is there a fixed bonus? Is there a performance linked bonus? Is there any ESOPs that you get as part of your employment package? Is there some vesting period for the stock options to come into fruition into your account, and so on? So all of those things you may want to check. The fourth part that you want to check is about your leaves. What is the leave allowance that you have? Do you have an option to encash the leave at the end of your period? What are the office timings? Do they have a flexible policy? Do they have some kind of work from home policy? These are all things that you may want to check, that it should be reflected in the employment contract. The next thing that you would want to check are the restraints on your employment. So this is something that's very important. There are 3 clauses that you must see clearly. The first clause is the confidentiality clause. What is the confidentiality obligation that is imposed on you? What are the things that is going to be kept confidential? Is there a data privacy aspect in that? Are you going to be dealing with any kind of data? And is there that kind kind of aspect, that is something you may want to see. If it doesn't make sense to you, if the clause is not making any sense to you, please ask somebody that you trust, somebody that you know, maybe a family friend or a lawyer friend or an HR friend, to decode that for you and explain to you what is it that you're signing up for. The second thing you want to check is the intellectual property clause, especially if you are entering a creative field or a scientific field where you're doing some kind of research or you're running some kind of experiments or you're even developing products, you're doing coding. When you're creating something, irrespective of which field you are in, you may want to check what the intellectual property clause says in that regard. Again, if it doesn't make sense to you, ask someone who can decode it for you. And the third thing you may want to check, which according to me is the most important thing, is the termination clause. What is the notice period if you want to terminate your employment, and how can your employment be terminated? Can the company terminate it? Can you terminate it? And if yes, then on what grounds? Are there any situations where you can be summarily terminated, which means you can immediately be let go? Is there any disciplinary process? After termination, are there any restrictions on your employment? Like you cannot take up alternate employment for a certain period of time if you're handling very sensitive data, etc. What does that look like? A lot of people forget to do this. I think it's really dangerous if you forget to do this. So please make sure that you read the termination clause in your employment contract properly. Now the next thing, and this is the controversial part of an employment contract, and that is the non-solicitation clause, the no poaching clause, the garden leave clause. They can be called by different names. They all don't mean exactly the same thing, but they are all part of the same universe. A non-solicitation clause or a no poaching clause simply means that it's a restriction on you that during your employment and for some time after, so sometimes there is a post-termination restraint as well, that you will not solicit means like take away either clients or employees or vendors or all of the connections from the company that you are working with to another company, or if you are going to start another similar business, you will not take them away. There is a non-compete clause which says during the course of your employment, you will not work with a competitor or another company which is in the same or similar business, or you will not work with any other company because you've given all your time to me exclusively. Now, sometimes both of these restrictions, which is a non-solicitation restriction or a no poaching restriction and a non-compete restriction, is also taken beyond employment. It could be anywhere from 3 months to 6 months to 2 years to 3 years, depending on the industry. The law on non-compete, especially post-termination non-compete, is still a bit ambiguous. It is safe to say that you cannot have a very strict non-compete that like you cannot work at all after your employment, because that will go against Section 28 of the Indian Contract Act, which is contracts and restraint of trade are void. However, some courts have also recognized the need of the corporations or the employers to protect their data, their trade secrets from getting leaked to a competitor through an employee, and therefore they have been willing to accept some very reasonable restraints. Reasonable meaning it has to be reasonable in terms of limited. If you say, for example, you cannot work with a competitor for 3 months after you have terminated your engagement with us, or you cannot work with a competitor within 10-kilometer radius of this office, so those, if you have restrictions which is based on time or based on geography, which is reasonable. So you're not restricting the person from working at all. He or she can still take up another job. It's just that they cannot take up the job which is directly in competition to your business for a very, very short period of time. And a general rule is between 3 to 6 months is more of a safer period. But this again is open to interpretation. It is open to jurisprudential change as things go. So this should not be taken as a rule. I want to disclaim this again. This should not be taken as a rule. With that said, let's move on to the employer's side. What should an employer be including in his or her employment contract? The first thing, again, that you as an employer, you want to be very, very clear about the expectations that you have from your employee. So you want to be clear about the hours of work. You want to be clear about the scope of work, the exact designation or the nature of work for which you have hired this employee. You want to be clear about the fact that you can maybe transfer this employee between offices if there is an overtime requirement, or if you want to be clear about certain disciplinary procedures if the employee is flouting some rules. You also want to be very clear about your rules. So you may want to have policies in place, whether it's a leave policy or it's a code of conduct or it is your POSH policy and so on, so that the employee knows exactly what is being expected out of him or her. You may also want to really think through what that employee is doing for you and craft your confidentiality clause, your intellectual property clause, your termination clause, your non-compete and non-solicitation clauses carefully. Please take professional legal help while drafting your employment contracts, and very importantly, when you are speaking to your lawyer while drafting the employment contract, please discuss your concerns with your lawyer. Please discuss your business plans with your lawyer. Please tell your lawyer that, this is the area of business and this is what I am going to do and this is what XYZ employee is going to do. These are the concerns I have. Or if you've had some bad experiences in the past, please explain that to the lawyer so that the document that the lawyer prepares will be fungible enough for you to use even in future. With that said, these are some of the general tips that I can give you when it comes to thinking through your employment contracts. Again, the rule of the thumb is always read through anything that you sign. If you don't understand something, please ask for clarification, ask for help. And thirdly, give your lawyer as much information as you can and discuss all of the things that you want the lawyer to think through and provide for you from a safety angle. I hope you found this video useful. If there's anything that you think I have missed, or if there's any question that you have regarding this topic, please write to me. I love hearing from all of you. You can write to me in the comments, or you can write to me as an email, thedailylawyer@gmail.com, and I'll see you in the next video. So share it, subscribe to our channel. I'll see you. Bye-bye.